seconds to go. Start. Lastly, learned counsel submitted that the division bench, while deciding the questions C and D, declined to give directions to the state government for creating promotion avenues and lifting of the embargo on posting of the employees in urban areas, and thus the reasoning adopted by the division bench in declaring Rule 59 as unconstitutional is apparently inconsistent with the finding recorded on questions C and D. On the other hand, Mr. N.M. Lodha, learned senior counsel appearing for the respondents, submitted that against the order under review, SLP preferred on behalf of the state stands rejected by the Supreme Court, expressing agreement with the reasons given in the order under review, and thus the order under review stands merged in the order dated 13 September 2018 passed by the Honorable Supreme Court in State of Rajasthan and another versus Bhupendra Singh Tarad and others, SLP Civil Diary number 21904 of 2018, and therefore the review petitions preferred on behalf of the state are not maintainable. According to the learned counsel, the lack of detailed reasoning in the order would not make the order non-speaking. Learned senior counsel submitted that all the grounds, including the ground with regard to earlier bench decision of this court upholding the virus of Rule 5 of the Rules of 2010, were raised before the Supreme Court, and after due consideration the Supreme Court expressed its agreement with the reasoning given in the judgment under review, and thus the SLP having been dismissed on merits, the decision of the Supreme Court is binding on the parties as also on this court, and for this reason the review petitions are not maintainable. In this regard, the learned senior counsel relied upon decisions of the Supreme Court in State of Maharashtra and another versus Prabhakar Bikaji Ingli, AIR 1996 SC 3069, Abai Maligai Partnership Firm and another versus K. Santha Kumaran and others 1998 7 SCC 386, Kanhaiya named and others versus State of Kerala and another 2006 SCC 359, Gangadhara Palo versus Revenue Divisional Officer and another 2011 4 SCC 602, Khode Distilleries Limited versus Sri Mahadeshwara Sahakara Sakari Karkhane Limited, Collegial 2019 4 SCC 376, Bablu Singh and others versus State of UP and others, AIR 2019 SC 305, and Capico Kerala Resorts Private Limited versus State of Kerala and others 2023 SCC 18. Learned senior counsel submitted that if the appellate court agrees with the reasons given in order under appeal, no separate reasons are required to be given. Reliance in this regard are placed on a decision of the Supreme Court in S.N. Mukherjee versus Union of India 1994 SCC 594, drawing the distinction between the order passed in exercise of power under Article 226 by the High Court and under Article 136 by the Supreme Court. Learned senior counsel relied upon the decision in Vishnu Dev Sharma versus State of Uttar Pradesh and others 2008 3 SCC 172 and submitted that analogy of requirement of the reasons to be recorded by the High Court while dismissing the writ petition could not be drawn to the Supreme Court's power under Article 136, relying upon a bench decision of this court in Jaipur Development Authority versus Shri Babulal Saini and others 2016 WLC Rajasthan UC 485. Learned senior counsel submitted that where a special leave petition is dismissed by the Supreme Court and no liberty is granted to file the review petition. The review petition against the judgment of the division bench on same grounds as taken before Supreme Court is not maintainable. Stop.